Tell me when. Hi, my name is Dan Fowler. I'm president of the Apartment Owners Association of Southern California. I want to welcome you today to a great seminar that I think you'll be looking forward to in just a few minutes from now. We have a great speaker. Our goal as an association with everything that we present to you is that you will discover at least one idea that'll help you make and or keep more money than ever before and or make your job of managing housing easier, more profitable, and simpler for you as an individual housing provider. And we want to thank you today for being on the program and on the stream. If you have a friend that might want to listen, especially up in Northern California, have a real treat today from an eviction attorney in Eviction attorney? Do we still have eviction attorneys? Yes, we do. And there are still some evictions going on in some areas, and he's going to be telling you a little bit about that, or a whole lot about that, this morning as you're listening on the stream. We're going to ask you to do one thing, and that is write letters. People call me and they'll say, Dan, what's the association doing about this? We got too much free rent. I've got people in my building. I can't make a payment on my mortgage, and I've got to do something about this. What are we doing? Well, we is you. The Apartment Owners Association is made up of members, and those members are you. And we're asking the association to do something today. And every one of you listening, you say, oh, I don't have to do it, or I don't have time. Well, fine, lose your building, or cause other people to lose their building because you don't do something about it. I'm asking you to write a letter. Write the governor a letter. Ask him to take a 25% cut in his pay. Not only a 25% cut in his pay, but to stop his payment, to stop all payments for all elected individuals in the state of California. You say, Dan, that's ridiculous. They'll never do that. Well, 20 years ago, apartment owners told me, Dan, they won't force us to offer free rent. Well, we can ask the politicians to join together. You know, they tell us, we're all in this together. Dan, we're all in this together. We have to sacrifice. We as you. We as the apartment industry, and I don't like it that way, and I hope you don't like it that way either. Politicians love it, though. Ask them, let's really make it join in together and be in this together by taking the same cut in pay, the same cut in retirement. Anybody on retirement, hey, cut that pay off and stop it. They've stopped your retirement pay. And so write your letters today, folks. I can't emphasize this enough. I'm going to put up on the screen the governor's address to write to. And you say, Dan, I'll email him a letter. You know, it's too easy for them up there just to go boop and delete, just to delete whatever you send. But the letters pile up. If we had sent 20,000 letters or over 20,000 letters, if every member would do that, can you imagine the effect that that might have on our governor, especially now that he's up for recall and said, oh my goodness, look at all these votes, these people that are unhappy with me. So you're going to mail it to the governor, write him a letter, tell him your situation, and tell him, ask him, take a cut. Stop receiving pay. You've stopped me from receiving pay. And then at the end of the period of time, we're going to ask you, Mr. Governor, and Mr. Politicians out there, all you people who have been elected, we're going to ask you to get your pay, get your back pay. You have to go to court and sue the state. So, oh, the state will just give it to us. Well, they don't just give it to apartment owners. You want to be in this together? Require it. Require. They have to file a lawsuit to get their money back. So write your letters today. Also, we'd ask you to donate. I'm going to put something up here on the screen. Ask you to donate to the Political Action Committee. We're building a war chest. We're going to eventually get involved in a major lawsuit, but it takes money, and we want to get a big war chest before we go after it so that we know we can go all the way to the Supreme Court. So we're asking you to donate to the AOA.pact.com/PAC if you'd like to go on the internet, or if you'd like to mail it in The address that you mail it into our home address, AOA Political Action Committee, 6445 Sepulveda Boulevard, Suite 300 in Van Nuys, California. So mail your donations in. Dan, how much should I mail? Every apartment owner out there, I mean, this is serious, folks. They're taking over your buildings. They're taking it away from you and giving it to somebody else. And what do they get in return? The politicians get votes. They're just buying votes with your money, with your property. And the property will last just so long. If you look in the socialistic countries, it works real well just for a while. Just for a while, and then pretty soon, it's all gone. People who you're taking it away from no longer have it, and they can no longer give it to others. So it doesn't work. We've got to explain to these politicians that it doesn't work. Remember, most of them have never held a job. Most of them have never run a company. They've never met a payroll. They've never provided one day of housing for anybody. So they do not understand our industry. They've messed up the housing industry with 40 years in California of rent control. They've caused this housing crisis, and they don't even know it. They think it's your fault. And the only way you're going to educate them is to let them know that. It's a real privilege to bring our speaker on. I'm going to introduce to you now, and he will introduce our speaker and tell you about it. And remember, keep in mind, what idea has he given me today that'll help me make it or keep more money than ever before, or make my job of managing buildings more profitable than ever before. So I'm going to introduce to you today Mr. Jeff Fowler, and he will be introducing the speaker. Jeff, turn it over to you.
Hello, everybody. My name is Jeff Fowler, and just so glad to have you with us today. Welcome. Northern California, welcome. Southern California, welcome everybody. SB 91 impacts the whole state, so the presentation today will be useful for everyone. And at the end, there will be a live question and answer, and our speaker today will be able to do that especially well for the local people in Northern California. If you have Southern California related questions, he's not going to be able to answer those for you, but general questions he will be able to answer. So I just want to say that before we get started. Also, please hold your questions in the chat until he's done, because you may get your question answered before that, so just hold it. There's the little blue help button if you're tuned in on AOAUSA.com, and if you click on that, you can type in your question and submit that, and then that'll get to me. There's Facebook, there's YouTube, there's our website, so there's different places that the questions are being funneled into, and then I will get those questions and be able to have those live questions after the presentation. Before we get there, again, Apartment Owners Association of California, we're here to serve you, and we're here to help you make and or keep more money, and to make the process of providing housing easier and more enjoyable. They call it passive income, but I don't know if it's very passive all the time. Right now, with these laws, it doesn't feel passive at all. But we're going to help you with that today, and at least to help you understand the things. If you're an AOA member and maybe you didn't get our email, but we have these that are these updated forms. The mandatory disclosure of rights is that one-time notice that you need to get out, and then we also have the updated 15-day, and then the updated declaration of COVID. So all these things are updated, along with the other form that's been updated is the rental application, because that also has been impacted. The questions that you can ask have been reduced, what we can ask. So just be aware of those forms, and that's just one of the benefits at AOA. We update our forms all the time, and you can get those. You can go online, you can get those forms and stay legal, and that's really what we want for you. And so again, we do have another speaker that's going to be sharing on the 11th about ADUs, and there's actually a $999 value attached to that, so you're not going to want to miss that. You'll be able to save $999. So go ahead and listen to that one. Also, I want to say 2 weeks ago, we had Robert Hall and Associates, and they offered a $50 discount on tax preparation for anyone that's an AOA member. Go back and check out that video, And so what I'm saying here is that in these videos, lots of times there's value that goes beyond just the knowledge. There's something there for you. So I would like you to subscribe. Don't want you to miss out on anything, especially if you're an AOA member. If you're not a member, I want to ask you to join. This is a great time for you to join. It's only $79 a year. There's no monthly, there's no unit cost. And so anyway, it's a great deal. You get the forums, you get advising on how to manage your properties, so many different things. You get the magazine. And speaking of the magazine, we got the new one out this month. And I want you to notice that here we have our speaker. And he writes a column for the AOA magazine. And he's been contributing to that for 10 years. He's been in this industry for 30. He's the founder of Beckman, Feller and Chang. And they do eviction litigation, landlord litigation. And let me see, check my notes and make sure I don't want to miss anything. Oh yes, so his location is very important. He services 7 Bay Area counties. So if you're up in Northern California, he's a guy for you. You can call and ask him questions and he can take care of you. And so it's my pleasure to introduce to you today Richard Beckman.
For their lovely introductions, and also a shout out to Israel Pareda behind the scenes who makes all this possible, because believe me, it's a bit of a choreography to get this thing in front of you for people who don't do it for a living, and I'm pretty sure that's us. Also want to make a slight mention of part of Dan's introduction describing me as an eviction attorney. I'd like to think I'm more than that, and the services I offer clients are designed to keep them from ever seeing the inside of a courtroom or ever needing to resort to the eviction process. So that really is the number one goal of my firm and its services, is to prevent landlords from needing our services in the eviction arena. But sometimes it happens, and that is the focus of this seminar, the current status of unlawful detainers in at least Northern California. There is a state law, which we're going to talk about considerably, but it has some allowance for local laws to have impact as well. So I'm going to now share screen, I believe, and hopefully you'll bear with me on this, to show the PowerPoint presentation that I have prepared for this presentation. So let's see. Let me hope I can move this thing through. So this is just the introduction, legal update and Q&A. Update on laws on unlawful detainer actions related to the COVID-19 pandemic. And that is my contact information. And I almost wore that same tie today, but at any rate. So brief review. First of all, we have to start with the sort of the status quo that existed just prior to the seminar. In August of 2020, the California legislature passed AB 3088. And as I note down here, it was really in response to a hodgepodge of local laws that were designed to provide various protections to tenants who were impacted by the economic impact of the pandemic. And not just the economic impact, but the spiraling virus infection rates, because the legislature understood that even tenants who were able to pay the rent but who had to relocate added to the risk of expanding the pool of people who were sharing the virus and passing it on to others. So prior to AB 3088, there was a tremendous amount of local restrictions on evictions for any reason whatsoever. The courts themselves were closed to unlawful detainers until about mid-August. So for those of you who recall, and I'm sure most of you do, the period from March until mid-August and early September was pretty much one of zero unlawful detainer activity. So the AB 3088, and I would note, actually, I was a little surprised. I actually got a call this morning from a former client who was calling to ask if she could serve a 3-day notice herself And that implicates a couple of issues, one of which is, yes, you can serve a notice as a landlord. You don't have to have a process server or any particular skill set. But she was completely unaware that the landscape had changed so dramatically that she was thinking she would be able to serve a 3-day notice for non-payment of rent. So I was a little surprised. I guess I just assumed that everybody understood at this point that the old rules no longer apply. And one of the primary rules, in order to avail yourself of the unlawful detainer process, requires that the landlord strictly comply with the rules, both state and local, that apply to those kinds of lawsuits. Just sort of a brief history lesson. The California legislature created the unlawful detainer statutes in the late 1800s, and they did it for a couple of reasons. One, they understood that the right of possession and occupancy of property was pretty paramount between the owner of the property and whoever was in possession, usually a tenant. So the legislature back then decided they were going to give landlords an expedited procedure to allow them to bring their claim to possession to the court as quickly as possible. Most California litigation usually takes about a year to get into a trial in a courtroom. The unlawful detainer statutes were designed to allow a landlord to bring their case to trial within 20 days of the tenant making an appearance by filing what's called an answer. That's an unheard of summary proceeding in terms of time. Now, those of you who've been through it know that there are many ways that tenants can use and their attorneys can use to delay that process, but the statutory concept is one of a tremendously expedited procedure. But what they gave the landlord on the one hand, they in effect took away on the other by requiring landlords to strictly comply. And that's the term that the courts use, strictly comply with all the procedures that are involved. And that includes the notice, the service of the notice, the language of the notice, allegations in the complaint, and various other issues that the tenant can use to challenge the landlord's proceeding. And if the landlord does not proceed very carefully, the landlord can often find him or herself back at square one, meaning their effort was stricken by the court, dismissed on demur is a typical result, and the landlord starts again with a new notice. So that's just a little bit of the background. And one of the primary features of that background was the right of a landlord to serve a 3-day notice for non-payment of rent. So AB 3088, in response to the pandemic, altered that rule by requiring that 3-day notice to be a 15-day notice. That 15-day notice has to have additional language, and that's all set forth in AB 3088, which was covered by AOA and myself in a seminar in early September. And what this seminar is going to do is update what the current legislation has done against the existing landscape of AB 3088. So this is the existing AB 3088 rules was that there would be no unlawful detainers before March 1st. That had to do with unlawful detainers based on non-payment of rent, unless the tenant failed to comply with the non-payment of rent rules that AB 3088 put in place. It didn't totally prevent landlords from proceeding in unlawful detainer actions. It just gave the tenant tremendous additional defenses to assert that would prevent the landlord from going forward, at least until March 1st. So the state law, though, did allow for other basis to terminate tenancies. For example, breach of the lease, the owner's desire to move into the property, other standard what are called just cause and no fault eviction basis. So the new notices that were required, all of which AOA has provided and keeps updated. So look to them, to that organization and its forms bank for your most current notices. So according to the AB 3088, that defines COVID-19 rental debt as any unpaid financial obligation that came due during what's called the covered time period. That was originally March 1st through January 31st. As we'll see, that's been extended to June 30th. That is, but still called the covered time period. And the covered time period was broken down between what's called the protected time period, which is the period from March 1st through August 31st. And in this particular time period, any rent that became due by the tenant that was unpaid was subject to a 15-day notice that also included a declaration that had to be provided to the tenant. And if the tenant returned the declaration, basically saying, I've been impacted by COVID-19 economically and I can't pay the rent. If the tenant returned that declaration, that's all that was required to prevent the landlord from proceeding through the unlawful detainer process for any rent due during that period of time, the protected time period. As with all these other provisions, it didn't forgive the unpaid rent, it just prevented it from being used as a basis for an unlawful detainer. The unpaid rent is still due, and there are rules that are in place about when that has to be repaid. And if it's not repaid by a certain time, then the landlord can proceed to try to collect it through a regular court action, like a small claims case or a superior court case. But again, we'll talk a little bit more about that as we go through. The transition time period was a significant change from the protected time period because first of all, it covered the period from September 1st through January 31st, 2021, and it did require the tenant to pay at least 25% of the rent that came due during that period of time. It didn't require the tenant to pay that rent each month. It gave the tenant until the end of January to collectively pay any unpaid amount of rent, the 25% of any unpaid amount. So if the tenant hadn't paid for September, October, November, December, January, 5 months rent, then the tenant would have to pay 125% of 1 month's rent by the end of January. And if the tenant didn't, then the landlord could proceed in February with the unlawful detainer. And again, all unpaid rent that cannot be demanded through the notice provision would be subject to collection actions. There was also, and there still are, the special rules for high-income tenants. Because one of the things that I think aggravate many landlords is that a tenant doesn't have to demonstrate any impact. They just have to sign a declaration under penalty of perjury that they have, in fact, suffered pandemic-related economic adversity. And if they provide that declaration without any support, then they are protected from the eviction based on non-payment of rent. But if a landlord has reason to believe that a tenant is a high-income tenant, and that's a defined term, I believe it's 130% of the local adjusted gross income average, then the landlord can require the tenant, the high-income tenant, to produce evidence that their economic impact prevents them from paying the rent. Now, there's some real restrictions on this. First, you cannot ask the tenant if they're high income. You cannot do investigation. The only way you have evidence of that is from the tenant's application. And that is, so that's a very strict procedure that you have to be very aware of. Also, it doesn't include anybody with an income of under $100,000, regardless of the local median. So so as it says, the landlord may require the high income tenant, if the landlord has evidence that the tenant falls in that category, to submit documentation showing the financial distress. And it has a variety of different components, but if you have an option to do that, you might want to look at that section carefully or consult with somebody that has. And a tenant who fails to comply shall not be subject to the protections, meaning they can be evicted for non-payment of rent. But again, potential consequence if you're wrong, if you claim the tenant is high income and you didn't have a reasonable basis to believe that, and the tenant establishes that, then they will prevail and they'll be entitled to their attorney's fees. So you have to be careful when you try to assert this particular provision. So SB 91, that is the state law that recently passed. I think January 29th it was passed. Well, there you go. January 29th it was signed into law, passed by the governor. And what it effectively does is simply extend the protections of AB 3088 through June. It also does something, though, for a lot of landlords, I think, long overdue, and it establishes what's called the state's emergency rental assistance program. There's just been a tremendous amount of anxiety on the part of landlords that, the tenants have protections, but the landlords don't. And there were some protections set forth in state and federal legislation regarding landlords' ability to request a mortgage forbearance and some other things. But effectively, the landlords were feeling, why are we the ones that have to suffer the burden of the tenant's inability or claimed inability to not pay the rent? So this emergency rental assistance program tries to address that, includes state and federal funds. We're going to talk a little bit more about it. But those are the two main components of SB 91. Extends AB 3088 through June and provides a method by which landlords can get reimbursement from the state for at least 80% of unpaid rent. Just the AB 38 extensions. I'm just trying to talk about that a little bit. This type is kind of small, but basically all the protections of AB 3088 were going to expire February 1st. And so SB 91, again, extends those out to June 30th. And it's basically the same provisions, prevents evictions for non-payment, for tenants experiencing COVID-19 hardship, available to any tenant who provides the penalty under penalty of perjury that they've not been able to pay due to COVID-19 related events. And if a tenant pays 25% between September and now June, they are protected from eviction, but they still owe the unpaid rent. And a new thing, well, this isn't new, this was also in AB 3088, but it does require a new form notice to the tenants to be served before February 28th. And this is something AOA can provide. And there was some uncertainty in the original legislation whether if a landlord failed to serve this required notice before the required date in the first in AB 3088, that was the end of September, and in SB 91 it's the end of February, whether that would prevent the landlord from proceeding to demand unpaid rent. It's not clear, but the safest course, the safe harbor, as they say, is definitely to serve this notice before the end of February. And again, this is a form available from AOA, and it's strongly recommended that every landlord who has a tenant who is behind in any amount of rent as of February serve this notice, regardless of any other notice that the landlord may serve. But as you know, at the very bottom, landlords may still proceed with other types of just cause evictions unrelated to a tenant's failure to pay rent. So that continued in SB 91, again, subject to some local restrictions, which we're going to talk about. So SBA extensions, again, a little bit redundant here. Before the SB 91, the February 1st was the deadline by which a court cannot find a tenant guilty of unlawful detainer unless they found one of the three particular provisions that they had been guilty of unlawful detainer before March 1st. And that's basically when a tenant who was already subject to eviction and there was a freeze on the court proceedings, those could resume as of the late August state law, or they fail to comply with the new rules pertaining to the non-payment of rent notices, or it's an at-fault just cause non-related to non-payment or unrelated to non-payment of rent. It also extends the date by which a landlord can bring an action to recover unpaid rent from February 1st to July 1st. And the cover time period, of course, extends now from March 1st through June 30th, rather than January 31st. Some of the other, this is related to the rent repayment fund that we just mentioned. One of the other elements of SB 91 that was not included in AB 3088 because there was no state fund to reimburse landlords for unpaid rent. But SB 91 has a couple of different provisions. One is it limits attorney's fees that the landlord would be entitled to recover if the landlord prevails on an unlawful detainer or even a debt collection case. And it limits that to $500 if the matter is uncontested. And that basically means a default proceeding where the tenant doesn't show up to defend the case. But if it's contested, limits it to $1,000, except for extraordinary circumstances. As you can see, that the court shall not award more than $1,000 for any case that was under ordinary circumstances. And the court has, as you can see in subsection B, in determining whether a case was litigated under ordinary circumstances, the court can consider the following: complexity and number of pretrial motions, the extent of discovery performed, whether the case was tried to a jury or to the court, the length of the trial, and then the wild card, any other factor the court, in its discretion, finds relevant, including whether the tenant or the landlord, or both the tenant and the landlord, would have been eligible to receive a rental assistance payment from the governmental entity or other third party. And then it recites to a civil code section. But basically, this is the court's way of saying, if we think the landlord had the opportunity to avoid coming to court because there was some other means of recovering the rent, such as the reimbursement fund, we're going to consider that and probably limit fees accordingly. And then this is another, I call this a real wild card. And I'm just going to read this. In any action to recover COVID-19 rental debt, and we know that that's any rental debt or unpaid rent that came due between March 1st and June 30th, the court may reduce the damages awarded for any amount of that debt if the court determines that the landlord refused to obtain rental assistance from the state rental assistance program if the tenant met the eligibility requirements and funds were available. So we're going to talk about this state fund in just a moment. But basically, this is the legislature's way of saying they may reduce it to 80% anyway. I don't really have an opinion on this as to its enforceability or, what's called the takings clause and some other constitutional issues. And I'm sure some of this stuff will be challenged by constitutional minded attorneys. But for the moment, this is what we have, this sort of vague threat that if you don't take advantage of the opportunity to recover some of the rent, then the court may, in effect, punish you for that. And so this brings us to the Emergency Rental Assistance Program. And this is the part of SB 91 that I think, really hopefully will provide significant relief to landlords who are just simply stymied by their inability to collect the rent. So basically it just says, and this is going to really have to get fleshed out in the website that the state is probably, as we speak, or as I speak, and you're watching, are developing because this legislation just passed a week ago, basically, and it instructed the governor's office to effectively create this web portal that will distribute this $2.4 billion or whatever it is. It's about that amount. According to a litany of rules. And as you can imagine, if you followed the news, having seen the state unemployment fund just be defrauded of literally billions of dollars by people making fraudulent claims. And that system was so woefully inadequate to vet applications that the agency, the state unemployment fund distributing agency, literally sent out billions of dollars to people who weren't entitled to receive it because the agency was simply unable to properly vet those applications. So I think the state is extraordinarily sensitive to that kind of concept here. So I assume that the web portal, once it's finally opened, will have a variety of requirements for both landlord and tenant to satisfy before anybody receives a check. At least I hope so, personally. That is our tax money. And there are a variety of provisions that we can already understand. One is it's limited to households with 80% of the area median income for that preceding year, and people below 50% will get priority. Unemployed households for the first or preceding 90 days also will get priority. So basically, I think this is both designed to apply to truly low-income tenants, but also those whose income was diminished considerably by pandemic-related events. People lost their jobs, or were working part-time or half-time, or had to go onto the gig economy, etc. So that is, and again, how these applications get processed is going to be interesting to see. And for the moment, we're not really sure. So if the tenant applies and qualifies, then the landlord can choose to accept 80% of any unpaid rent owed from April 1st through March 31st, And if the landlord accepts this 80% reimbursement, the landlord has to agree to forgive the remaining 20%. So that's the compromise that was made. 80% and call it a day, or chase the tenant through small claims and possibly into bankruptcy, or every individual landlord will have to make that determination. Again, assuming that the tenant qualifies, that's going to be, and there's still funds available. But it's a pretty healthy pot, and judging from some of the things I've read, it should be sufficient to cover what's estimated to be the amount of total unpaid rent, roughly. So it'd be interesting to see how that works out and who takes advantage of that opportunity. If the landlord chooses not to participate, the tenant can still apply, and they will get, if they are approved, they will be paid directly 25% of the unpaid rent for the covered period that they can then use to satisfy the requirement that they pay 25% of the rent during the protected period, the transition period, to avoid eviction. They'll still owe the back rent, the remaining 75%, but they can't be evicted for it. There's also a provision down here: qualified tenants can access funds to cover 25% of the prospective rent for the months of April, May, and June. Because again, the program terminates at the end of June, subject to being extended by an additional, state legislation. But it is designed to reimburse up to the period when the website is functioning, and then it'll provide prospective rent payments going forward. And as it says at the bottom, program will be stood up to begin accepting applications no later than March 15, 2021. Again, it'll be interesting to see. I believe they've selected a vendor that is pretty experienced in distributing housing assistance. So, I'll be optimistic that the organization that they've identified as the vendor will be able to, build this website and make it functioning, and it'll go relatively smoothly. But at this point, that's just speculation. So a little bit of the details of the rental assistance. It says $1.5 billion, but that is from federal funds that are going to go directly to the state. And then there's an additional, I think, about $1 billion that's going to go directly to municipalities that have, I think, over 200,000 people. And there's a website that is available that kind of shows that breakdown. But I think for our purposes, it doesn't really matter. There's either going to be money in that pot or there's not. But again, it's eligibility for the tenant, income no more than 80% of the area median income, documented financial hardships. I assume this means more than just simply submitting the declaration that the tenant has to submit to the landlord, which again doesn't have to prove anything. It just has to say, I've been affected and can't pay the rent. Demonstrated risk of homelessness or housing instability. I'm sure that's easy enough. And priority given to incomes no more than 50% of the AMI. And it can be used for rental arrears, prospective rent payments, utilities. That's helpful. Any other expense related to housing is provided in the law. I'm not sure there was a lot of detail on that. But again, the first step is just simply getting that system operating and seeing how it goes, and see if it just starts distributing 80% to the landlords or 25% to the tenant, and take it from there. Program terms: landlords can apply for funding and approve up to 80% in exchange. Again, kind of covered this, a little bit redundant. And if the landlords do not apply, the tenant can apply individually. So pays 25% of the 3 months of future rent. Now, this is from the state's website, actually. So it says assistance is paid directly to the landlord. But again, I think until that website's up and the application process is clear, I'm not going to spend too much time on that issue. Prohibits landlords from proceeding with an eviction if they have not first notified the tenant about the rental assistance program. Now, again, this is a form that's required to be provided. And again, this is an AOA form that all members are strongly encouraged to take advantage of. And then this is this last section here, additional information about the extension of the Tenant Relief Act and the new state or local rental assistance programs can be found by visiting that website. I'm not sure about, I haven't called that number, but I have been to the website, and it's, it basically says, here's what we're doing, and we're trying to get it going. There's some links to some interesting other websites, like the one I was describing that talks about how the money, where the money's coming from and how it's being distributed to by the state or to the local cities directly. So again, I would recommend checking that website out for additional information. And again, I think that's where the portal is going to be for the eventual applications to get into this reimbursement program. So that's basically SB 91 as it updates AB 3088 and supplements it with those additional provisions. Federal law, and you probably heard about the CDC order. It was originally going to expire January 31st. It now goes through March 31st. It hasn't really come into play a lot, at least in my experience, because as noted at the bottom, it doesn't apply to any location that has the greater protections. And while Governor Newsom does not make this determination, that will only come from a court. At least he is on record as having the opinion that the state laws are stronger than the CDC moratorium, partly because it doesn't necessarily apply to income limitations as the CDC order does. But again, that's something that is, a lot of this stuff only gets settled when an appellate department of the California judicial branch makes a written opinion that binds the lower courts and agencies. And that really hasn't happened yet, to my knowledge. And I'm a little surprised because there are procedures for the appellate districts, 1st through 6th district, to issue expedited opinions on pressing legal issues. But I get updates that I review every day, and I have not seen one yet interpreting AB 3088, which, again, I am surprised. So we were going to cover this in our original seminar back in September, but ran out of time because there was so much to cover on AB 3088, and I went through it in a lot more detail. And for those of you who either missed AB 3088 or would like to review it, I believe that the seminar materials that I've provided are available through AOA, but if they're not, if you want to send me an email, I can send you that presentation. So it's a good primer for AB 3088, which again is primarily just being extended by SB 91. Issue of stated preemption. This is, to me, this is probably the most important issue. There's a rule that says a state law preempts local law if the state law is designed to, as I think the expression is, fill the field of whatever the issue is. And this issue leads to epic legal disputes as to whether a state law has preempted a local law or not. And often it goes to the California Supreme Court because it's such a thorny issue. And in this case, probably no less than some of the others. Is that my beeper telling me I'm talking too long? No, I don't think so. At any rate, there's two provisions that was in AB 3088 and are repeated in SB 91. And the first one simply says that any ordinance, resolution, regulation, or administrative action adopted by, and I have to move this, adopted by a city, county, or city and county, and that refers to San Francisco because it's the only city and county, in response to the COVID-19 pandemic to protect tenants from eviction is subject to all of the following. Any extension, expansion, renewal, reenactment, or new adoption of a measure, however delineated, that occurs between August 19th and June 30th shall have no effect before July 1st, 2021. Now that seems pretty clear, right? I mean, I think they couldn't have made it any more extensive or all-encompassing. Extension, expansion, renewal, reenactment, or new adoption of a measure, however delineated. So yes, that pretty much covers it. Made by a local entity, jurisdiction, just shall have no effect before July 1st. So in effect, any rules passed by cities or counties after August 19th that purported to protect tenants from eviction are, by this measure, simply invalid until at least July 1st. Now, below that is the wild card, and it has confused. I've spoken to city attorneys and rent boards and other attorneys, and there's a lot of variation on there's no consensus, I think, on this. So the section B of this particular part of SB 91 says that, however, this section does not alter a city, county, or county's authority to expand, renew, reenact, or newly adopt an ordinance that requires just cause for termination of a residential tenancy, or amend existing ordinances that require just cause. And then refers to, as long as they're consistent with subdivision G of section 1946.2 of the Civil Code, although nothing they do shall apply to rental payments that were due between March 1st and June 30th, just to make that clear. So I think what this refers to is section 1946.2 is a provision that came about through AB 1482 that was passed in 2019. And for those of you keeping score at home, that was the statute passed in maybe August of 2019 that for the first time enacted statewide rent and eviction controls. It was pretty controversial at the time, but it basically said that unless you're in a jurisdiction that already has a rent and eviction control law, the state law would apply. And that basically said, like a lot of the local rules, if you don't have just cause, you cannot terminate a tenancy, and rent increases would be limited to a certain amount. Under the state law, I think fairly generous, 5% plus the consumer price index. Most local rent control ordinances limit rent increases to no more than the CPI, and in some cases, even less than the CPI. So the rent restriction didn't seem to be quite too onerous. But again, that's a matter of opinion, I suspect. But so this is what has thrown this preemption issue into confusion, because, and I reached out to the author of AB 3088, Assemblyman Chu and his staff, and tried to get some clarification, because I think there is no consensus. And their response to me was a little bit, well, we're not really 100% sure. We know there was a lot of discussion, but, it's up to a court to decide. So, and I actually had a case that was set for hearing Tuesday of this week that would have addressed that issue, because it was in San Francisco, and San Francisco, which I'll talk about in just a moment, passed an ordinance in October by the Board of Supervisors that prevented any evictions based on anything except for non-payment of rent if it qualified under AB 3088, now SB 91, or was for public health and safety. But I had an owner move-in case, and the notice had expired, and I believe that this state provision prevented San Francisco from enforcing its local restriction on an owner move-in basis to terminate a tenancy. So the opponent, housing authority tenants or housing assistance tenants, filed what's called a demur, saying, no, we can't proceed because San Francisco prohibits it. So the argument was before the court whether this SB 91 preempted the local ordinance or not. But I think because both sides were, uncertainty is nobody's friend in these things, we agreed to settle that matter before the hearing. In fact, I got emails from colleagues asking me, what the heck? We were all waiting for that. And my response was, well, you must have some of your own cases, so feel free to bring them. I have to, do what I think is best in my client's case. So unfortunately, and that would have only been one judge's decision. And judges who make decisions at what's called the trial court level do not bind other courts or other judges or other cases. Now, they may be persuasive, and particularly if you come in front of that same judge, but for a variety of reasons, you may not, in which case you're up to another judge's interpretation. Only if that matter would be taken up to the appellate department, the first district in San Francisco's case, would we get a true ruling on that issue. And I can't wait for that to happen. It's long overdue. So the issue of preemption remains uncertain. There's not much more I can add to that. Now, the preemption of local laws related to COVID debt repayment are not uncertain. The statute, both AB 3088 and SB 91, are very clear. No local law can affect the rent payment and eviction provisions in the state law. Just simple as that. As long as it was not in effect after August 19th. I should say, laws that were in effect before August 19th remain valid. So that is something to be aware of. But so many of the ordinances got extended and so on after August 19th. Those are the ones that are absolutely preempted. And then SB 91 also deals with the repayment period, because a lot of the tenants who submit the declarations still owe the rent, but there's a lot of uncertainty and a lot of local variation as to when can a landlord start requiring the tenant to pay that rent back. And some of the provisions had as much as 12 months after the end of the pandemic or the state of emergency, which is still in place and will be for the foreseeable future. So SB 91 just simply said that, and the rules are set forth here, no matter what your local law said, pretty much the repayment period is going to start on August 21st. August 1st of 2021. So that is that's I think an undisputed provision. Although again, you have to get into small claims court, and that's still not permitted. So that stuff may yet get changed. And then just speaking of local ordinances, and I need to check the time. 10:55. I'm not sure. I think we can get through this. And I'm just going to, because anybody who has a case in any particular jurisdiction has to carefully review the situation in that particular jurisdiction. This is really just kind of an overview and a survey of some of the local ordinances. And they can be both city or by county. And as I think, as I mentioned earlier, San Francisco is the only jurisdiction that its boundaries are both the city and the county. So it's kind of an odd duck. But Alameda County, for example, encompasses Berkeley, Oakland. It's got my 5-minute warning, so I think that'll be enough to get through this. Thank you, Israel. But anyway, Alameda County, like most counties, encompasses cities within the county. For example, in Alameda, Berkeley, Oakland, Hayward, Fremont, each of their own have, significant opportunity to pass ordinance and stuff. But the Alameda County ordinance just said basically, regardless of what your local city has done, and this was passed in March, so it's presumably going to remain valid. Basically, it just put an eviction moratorium for any basis for unlawful detainers, except for public health and safety and non-payment. For basically that's it. Just public health and safety, or non-payment of rent if the tenant doesn't comply with the requirement for providing documentation. So because this was passed before August 19th, when AB 3088 was enacted, it probably remains valid. And this provides now. I think this is going to be a little bit of a question. This one provides tenants up to 12 months starting from once the eviction moratorium is over. We'll strike that. Repayment things, you just need to check your own individual counties very carefully. And I'll leave it at that. Contra Costa County had an ordinance, but it expired January 31st. So it is basically an area that is covered only by the state law. Unless generally speaking, I'll leave it at that. Marin County, also similarly, it did a recent endeavor to bar evictions, and it's going to be preempted. So as per SB 91, provisions related to the rental payment are governed by SB 91. And there's a website that provides that information. San Mateo County had an ordinance moratorium on evictions and expired August 31st, so it's no longer in play. Santa Clara, same thing, basically. And again, you can get the information directly from the local jurisdiction's website. San Francisco, I talked about, so I won't use any more time on that one. Oakland, which again is in Alameda County. So to the extent that the Oakland provisions would be more protective, I'm not sure how it can be, because the Alameda County was pretty protective. So, and Berkeley, the only reason I'm bringing this up, because again, like Oakland is covered by the Alameda County ordinance, but it had allowed, as Alameda County did, evictions based on the Ellis Act. That's the state law that allows a landlord to go out of the rental business. But then in December, Berkeley passed an ordinance amending its emergency legislation to include Ellis Acts as unpermitted grounds. I don't think that's going to survive. But if you have such a case, I guess you'll probably find out pretty soon. San Jose, let's see, as of September 1st, they recognized that their moratorium was preempted. Some of the local jurisdictions actually acknowledged that the state law preempts their own stuff. So I think San Jose is one of those. And that brings us to the question and answer. And so I will turn it back over, I believe, I'll stop sharing and turn it over to Jeff, I believe.
Thank you, Richard, so much for that.
My pleasure.
And wow, there's been so much that's gone on here. Pretty crazy. And man, I just want to say, please, like Dan mentioned, you got to write the governor, and you need to write your local officials and make your voice heard on these things. And yeah, it's just crazy. So we'll go ahead and we'll get started here. We have Brian. As a landlord, if your investment property is in forbearance due to the decrease of rent received during the transition period, and tenant was given a 60-day notice that the lease will not be renewed, is the landlord required to allow the tenant to remain in possession? Or can landlords serve a notice if the tenant decided not to vacate to start the eviction?
Well, I think first of all, the mortgage forbearance rules, I'm woefully unprepared to address. I have focused on the effects of the legislation on the landlord-tenant unlawful detainer area, but there are protections that are in place that allow property owners to request mortgage forbearance, and some of that information is widely available online. And I think it's relatively easy to locate through a Google search. As to the question about the 60-day notice, it does depend on the local jurisdiction. There are almost no occasions left where a expiring lease results in the tenant's obligation to vacate. Prior to any eviction control measures, whether they be local or city or county or state, which would be AB 1482, when a lease for a term expired, if you had a 1-year lease and it expired and the tenant remained in possession, the tenant was, as the expression goes, unlawfully detaining the property and could be subject to an eviction lawsuit the following day. They didn't require notice. They weren't entitled to notice. That's just simply the state of the law. But when the eviction control measures began to be enacted, again, whether they be local or in 2019 state, that was no longer the case. Tenants are allowed to remain in possession, and the lease simply rolls over to a month-to-month agreement on the same terms, which is typically what would happen if the tenant stayed in possession and offered the rent and the landlord accepted it. That was existing law anyway. But now it took away AB 1482, along with local variants, took away the obligation of the tenant to move out at the expiration of the lease. So whether you can serve a 60-day notice depends on your circumstances. And if it's a single family home and you provided the proper notice, then it's exempt from AB 1482. But the pandemic legislation applies even to single family homes, meaning you got to have a just cause, like the tenant's doing something wrong or you want to move in. So again, you're going to have to get a personal opinion, but my guess is that it's unlikely you can just serve a no fault, no cause 60-day notice.
Okay. Here we have Barb, Hernandez, and Carrillo. Now with the new eviction moratorium, can we still give tenants who are not paying any rent the second 15-day eviction notice from the September 2020 through the January 31, 2021.
If you mean by the second notice, the one that actually demands the rent, because that the I would call it the pre-notice notice, for lack of a better description, but it's the notice that it was required in the earlier legislation to be served by the end of September, and in the current legislation to be served by the end of February. That basically notifies the tenant of these various protections and places to get assistance and so on. That is separate from an actual 15-day notice demanding the rent, which has to be served in order to trigger the tenant's obligation to return the declaration. So nothing's changed there. It just extended the deadline to June 30th, by which the tenant is required to pay at least 25% of any amount demanded through that 15-day notice.
Here's a good question. This is Sarah Parker, and this came up last week as well with Dennis Block speaking. But does SB 19 apply to commercial real estate, commercial tenancies?
No, local legislation might, but SB 91 and AB 3088 were strictly limited to residential tenancies.
All right. Here we have Ming Chen. How does the 80% rent work? Should it be initiated by the tenants? If so, should it be initiated by the tenants? If so, how about if the tenants do not do it? If I sign to give up the 20% rent, but still don't get the 80% rent.
You know, again, how that's all going to literally play out on the website, and the application procedure and the qualification procedure, and then the execution procedure, meaning how do I get my money? I just don't know. I mean, I don't know that anyone does until that website begins to go online and you start to work your way through it. Whether landlords, I believe landlords will be able to initiate a request for payment, and then they'll be required to, again, verify that they are waiving the balance. Tenants may be able to initiate the same application. It's just not clear, and really you're just going to have to keep an eye on that website and look into it when it gets developed. I mean, there will be more summaries like this. Other people will publish updates and so on, but I think the website will be the most interesting way.
The title of this talk?
Great. And here's Maureen. What are the laws about applying payments received before March 2020, as well as during the various phases since then?
Well, typically, rents that were received by a tenant could be, unless the check actually specified the month of the rent that they wanted to pay, could be applied to any unpaid period. Like if you got a check from a tenant in March and they owed for December, you could apply that check to December and they still owed for March. And that had to do mostly with the fact that the right to bring the right to serve a 3-day notice only lasts for 12 months from the date that the payment was not paid. Mm-hmm. So if that were the case, that December missed payment, you would have until the following December to serve a 3-day notice demanding it. After that, you'd have to go through the regular collection procedure. But AB 3088 and SB 91 both provide that the tenants, any payments made by the tenant are applied to the month in which they're received, whether the tenant designates it or not. So, if it comes in the middle of, on the cusp of 1 month versus another, there's some issues that aren't totally clear, but that one's pretty clear that you can't go back and apply it to unpaid rent periods.
Great. And I know that in the chat, there's some people wondering if you're going to answer questions about Los Angeles area evictions. And you guys, you probably got in a little bit late. At the very beginning, I announced that Richard Beckman, he's in Northern California, so he is covering the things up there he can speak to locally. The questions that I ask right now, some of them apply to local issues and others are general. And so you can continue to listen in if you'd like. And but anyway, just be patient with us. There are tons of questions, and we're not going to get to all of them. We have about 20, 25 minutes to continue to ask questions. So we're going to go for it, and we'll just try to hit them as fast as we can.
Right.
Go ahead.
Jeff, I would note that the state law applies statewide, of course.
Right.
The only issue is whether there are local ordinances that snuck in under it before August 19th that are still in force, or whether the court rules that post-August local laws are also enforceable. And I personally have a little bit of a vested interest. My daughter just moved into a little duplex in LA. I think it's the Highland Park, but I'm not 100% sure. So I actually have a new interest in getting better acquainted with the local laws down there, but not for purposes of this seminar. So,
right. And also, I do want to mention for those of you that are watching in the Los Angeles or Southern California area, last week we had the 2021 legislative update with Michael Brennan. And so if you're on AOA US, if you're on YouTube and you search AOA USA, we have a channel there. And on that channel, you'll see just the last post before this one is that 2021 legislative update. You can look at that, and a lot of questions were asked. And so you can go ahead and listen to that, and most likely you'll get your question asked. And so anyway, just want to give that, we're an association for the entire state. So we like to have these focused ones where we can meet the needs of our members. And so here we are, we have Richard Beckman, and thank you so much for doing this. I'll stop talking and start asking more questions. Here's a Section 8 question that I think is a good one. I have a Section 8 tenant. Can I non-renew his lease to get him out? He's a problem.
Well, Section 8 is an added, element of complexity, of course. Most of the local jurisdictions included, originally Section 8 was totally exempt from local rent and eviction control. They're still exempt from rent control because of the fact that the rents are set by a government, a federal government agency. But they began to be covered by the eviction control procedures. And I think Dennis Block, one of the AOA consulting attorneys in Southern California, he got a published case that demonstrated how tricky some of that can be, because his client, I believe, wanted to not renew a Section 8 contract and use the what's called other just cause basis. And they just wanted to stop doing it. Basically, they had a different idea or interest for the property. And so the local housing authority agreed, terminated the contract, stopped the assistance, which is usually 80-90% of the rent. But then the tenant argued that the fact that the Section 8 program could be terminated did not qualify for just cause under the local Los Angeles rent stabilization ordinance. And the court agreed. And so in that case, that landlord was stuck, I believe, unless they did the Ellis Act to go out of business, with a tenant who was only obligated to pay their Section 8 share, which was probably 5 or 10% of the rent. So that was a hard lesson to learn. So, again, Section 8, I approach very carefully. But depending on where you are, you may be able to not renew that contract, but a lot of the same analysis that I just discussed with the person with the 60-day notice question would apply. You have to look at it individually in the jurisdiction that the property is located.
Great. Here's another Section 8 question from Saeed. If a tenant is on Section 8 and not paying his share, can Section 8 share be considered for the 25% rent payment?
Yeah, that's a good question. And again, I wish there were no Section 8 questions, but we should do that. It was my understanding there would be no Section 8 questions. I mean, just to paraphrase that Saturday Night Live moment. But no, I think, well, absolutely. The rent paid by the housing authority will be included in the rent received by the landlord. So I think that's a pretty easy one. Now, if the tenant doesn't pay the remaining 25%, I mean, the housing authority probably is paying more than 75%. It usually does. But the tenant is, now the question is the tenant only obligated to pay 25% of its remaining percentage? I mean, at that point, you're talking an amount that's hardly worth the effort. I mean, in many cases, but I suspect that that's going to be the situation. The tenant is only obligated to pay 25% of his or her share. But that's a really good question. Whether they're obligated to pay 25% of the entire amount, I don't know. It's a good question. I will admit it, and maybe a little research on that would be warranted. So, if you don't get a better answer, give me a call and I'll see if I can figure that one out.
There we go. Thank you. All right. On Facebook, we have Maria question. If a tenant stops paying January 2020. The last payment was December 2019, 2 months before the pandemic started. Can she claim that she did not pay because of the pandemic?
Well, no, she cannot. The pandemic protections only began to apply for rent that became due, I think, after March 19th, but, effectively. So really that would be effectively April, because most rents are due at the beginning of the month. Now you could have served non-payment of rent notices way back then, but now any notice that is served, it's unclear if the 12-month period preceding March is going to be extended for purposes of 3-day notice. For example, could you serve a 3-day notice for pre-March rent? I don't think so. Every notice has to be a 15-day notice. But if it demanded rent prior to March, I don't think the tenant is allowed to contest by saying they are protected by the pandemic. That's another good question. And I'm surprised it hasn't come up more, but I would have to check to be certain. But I know you have to serve the 15-day notice, but I don't believe the tenant can avoid paying the prior rent that wasn't covered by the pandemic protection, meaning a declaration that I can't pay the rent that accrued from March through June because of the pandemic. But that's one question that you're either going to have to get a local opinion on, or another research project for me.
There we go.
I know. And that's why judges don't like ever taking anything under submission. They just like making a decision, getting it off the plate. Otherwise, it just keeps stacking up. So I hesitate to do that. But again, it's a valid question. And if you can't get a better answer, let me know.
Great. And here's Karen on YouTube. If the rent relief pays the 80%, does the tenant need to pay? Does the tenant still owe the 20?
No. And thank you for an easy one. I mean, some of these, really, I appreciate easy ones. No, the legislation is very clear. If the landlord accepts the 80% from the fund, they waive the other 20%. The tenant's off the hook for it.
Right. And then John Murray, it's kind of it's different question there, but the same thing. Why would you not take the 80%? Is there a reason to not take it?
Other than waiving the 20, but again, the cost of chasing the tenant for the extra 20% versus the likelihood of actually getting it, to me, if it were me, I think it would be a pretty easy call to take the 80% and just move on.
Yeah, great. On YouTube, we have a fictitious name there, but I want to sell my city of Danville. It's Contra Costa County, SFR, with a month-to-month tenant who does not want to move. He is current on his rent. Does SB 91 allow this eviction with a 60-day notice?
Well, it's a good question. And like I said before, the state eviction control law in 2019 would have exempted it does exempt single-family homes from any just cause requirement. If you've given there's a pre-notice that you have to give them that says your tenancy is not subject to any eviction control procedures, and as long as the single family home is not owned by a corporate entity. But generally speaking, your average single family home owned by a person who's rented out was exempt from the just cause requirements of AB 1492. But I think from my reading of the current pandemic legislation, AB 3088 and SB 91, it applies to everything. And so you have to have a just cause ground like owner move-in. So if you sold that property, the person that buys it would be able to do an owner move-in notice, give them a 60-day notice. I don't think there'd be any problem with that. But that's for a prospective owner to determine. You, as a seller, that's not information you want to share. That's up to the prospective buyer to do their own research. But that would be my expectation. They'd have to wait 60 days, but and so you wouldn't be able to provide them a vacant unit. But they would have the ability to get possession for their personal use.
Okay, on YouTube, this is good. Just a clarifying question. If we've already served the AB 3088 version of the 15-day POQ, and our case has already been filed, do we need to send a new one before the end of February?
Well, I mean, if your case has already been filed and it's proceeding, then most likely you're going to resolve that either by agreement or a court decision. And once you've terminated a tenancy, the tenant no longer owes rent. They're just liable for what's called the per diem damages. I suppose I'd probably serve that. I'm going on a bit of a limb here because, I haven't really thought that through, because you don't want to prejudice your existing action. Like if you accept rent from a tenant, after you've initiated an action, you waive the right to proceed on that action. So that's a basic rule of law. Serving the new notice by itself probably will not have any negative impact. It just protects you in case you lose this case or for whatever reason, and the tenant doesn't pay rent going forward. So probably it's okay to serve that required notice. But if you have anybody assisting you, you might want to get a specific, answer to that question.
Great. And here's on YouTube, we have Josh. For the protection period monies owed of March to August, what's the process we need to follow in March 2021 to start the collection of these funds?
Well, that date, the collection date, has been extended out anyway to August 1st or July 1st. Actually, I have, there's a little confusion about that. I had a city attorney from one of the local cities ask me, isn't it August 1st? I sent him the language from the legislation directly, and it says July 1st. But I think AOA, in fact, I think of the blurb that AOA sent out mentions August 1st. So I'm not sure where there's a disconnect, because, again, the legislative statement, seems to say very clearly none of these actions can begin before July 1st. But putting that aside, again, each local jurisdiction had some restrictions on when the repayment period would begin. Some said it can't begin until after the end of the declaration, state of emergency declaration. So, I have to go back and look to see whether AB 91 affected any of those rules that were in place before August 19th. Anything that was put in place after August 19th for sure will not apply. And so therefore the repayment period cannot begin any later than August of this year. And then if the tenant doesn't pay it, then you can proceed through the small claims case. But, if you have that, you got to just look at it carefully and make sure that you're in compliance with local law if it wasn't superseded. Otherwise, presumably after August 1st, you can make your claim for the unpaid rent in a small claims case, which, again, one of the provisions of AB 3088 lifted the jurisdictional limits, because it was limited to $10,000 for purposes of COVID-related rent debt. That has been lifted, and there's no restriction as far as I can tell.
Is SB 91 a replacement, and is 3088 now retired, and SB 91 is the new law that we're dealing with?
SB 91 basically copied AB 3088. And in fact, if you go to the California legislature's website, and they'll have a provision where you can type in SB 91, and you can bring up that legislation and it's actually pretty interesting, because you can see the various stages it went through. But if you bring up one version of it, it highlights the changes. It makes it a lot easier. What I used when I went through it. So it's really an overlay over AB 3088 with some changes. So hopefully that answers the question.
Okay. All right, let's take a look here. What resources do I have if a tenant signed a COVID-19 declaration, but I find out that they're working? Again, this is one of the more frustrating elements of the AB 3088, and I don't think it changed from SB 91. It just gave the tenant the right to submit a declaration under penalty of perjury that they couldn't pay the rent because they were impacted by the pandemic. There was just no way, as far as I can tell, to challenge that. If you brought an unlawful detainer and they produced as a defense their declaration, the court was obligated to end the case right there. So there did not seem to be any way to investigate that. Unlike for example, the high-income tenant, if you have evidence that they, on their application, say they make a certain amount of money, then you can require them to produce evidence of the impact. But other than that, I don't think there's any remedy for a tenant who lies.
We're not going to be getting the district attorney to charge them with perjury, I'm pretty sure. It's just going to be one of the blunt force impacts of the legislation.
All right. Helen Young on YouTube. Do we have to give this new form regarding SB 91 for tenants who are not behind on rent in the San Mateo area?
Well, the provision just says if your tenant hasn't paid rent as of February, you have to provide this notice. So no, strictly speaking, you wouldn't, because they're not behind. But again, I would just do the blanket. I would serve every tenant with this notice and just eliminate any of the issues. It's just mail it out, keep a proof of service that you did so, and simple and probably maybe helpful.
Okay. Here's a question on YouTube from Anna. A housing advocate says, I cannot evict a tenant to sell a property unless owner move-in occurs after the sale. We have a buyer who's a developer. Is there anything they can do?
Well, again, much like the answer I just gave to the prior question. Normally, in a single-family home situation, you could have terminated tenancy without cause because it was exempt, but not now. So I think if you're going to sell it, the buyer is going to have to make that determination that they're going to be able to proceed. And if it's a developer who's buying it for investment purposes, then they wouldn't be able to do an owner move-in. But again, that I always tell clients who are selling property, do not make any representations about what the buyer can or cannot do with the property once they buy it, because that's for them and their counsel to determine. Simple as that. And if they make the determination that, yes, all right, under the current state of the law, I can do an owner move-in, it's going to take me a 60-day notice. I mean, it will impact the purchase price. I'm be realistically realistically would be unrealistic to anticipate otherwise, because being able to buy a home that's vacant and move right in is worth more than buying a home that's occupied, even if you have a clean cut basis to serve a 60-day notice to terminate that tenancy. You still have to wait 60 days. So there's no doubt that it's going to impact the value. But until the pandemic legislation goes away, I believe that's just simply part of your arrangement.
Great. And some people, you've said it more than once, but just again to bring clarity, what happens if a tenant does not sign the declaration but also does not pay the 25%? Can you evict now or have them wait, or do you have to wait till July 1st, 2021?
No, I mean, if the tenant doesn't return the declaration, then you're free to proceed in unlawful detainer after the 15-day period expires, just as if they served an old style 3-day notice and they didn't pay the rent on the 4th day. I mean, the 15 days is extended because it only includes business days. Previously, 3-day notices served on a Friday expired on a Monday because weekends counted. But then in 2019, I believe, I'm pretty sure that rule was changed to not count weekends and holidays. So a notice served on Friday expired on Wednesday instead. And so the 15-day notices themselves, the 15 days does not include weekends and holidays. So, it reaches out there probably like 22 days, once you add the holidays or any holidays, but the weekends for sure. But if the tenant doesn't return the declaration, you can proceed on that unlawful detainer, just as if it was a 3-day notice. Now, there is a provision in AB 3088, which remains in SB 91, that the tenant can make a sort of a last-ditch plea to the court that they didn't provide the declaration because it was excusable neglect and get relief. That's up to the court to decide whether that was a legitimate excuse. But if the tenant doesn't respond to the unlawful detainer, let's say you serve a 15-day notice properly, include the declaration, the pre-notice notice, all that, and the tenant doesn't respond, and you file an unlawful detainer, which you'd be entitled to do, and serve it on the tenant, and they don't respond, then you can take their default. So, yeah, I mean, it's certainly possible to go through the procedure and regain possession in this climate, but it basically involves the tenant not taking any effort to defend it.
Okay, we have loads and loads of questions. Could you take at least one more?
Yeah, sure. I am I'm watching the clock. I see 11:28. I think, but anyway, sure, please.
Yeah, so we'll just do one last one, and it just, I think this is a good question because you touched on it, but yet I think circling back on it, it's good. Would the 80% relief include unpaid utilities too?
Well, a good question. Presumably, because it listed in the items that it will be that are available for reimbursement utilities. At least it lists utilities in the section that the tenant can submit as part of their request for funds. So if the rent's $1,000 and the landlord's paying $200 in utilities, so it's a total of $1,200, do you get 80% of that? I would think so. But again, until that website is developed and the application process is right in front of you with checks and boxes to fill in, it's not 100% clear.
Okay. Well, thank you so much for your time. I know that you have a lot of clients to take care of.
Well,
and hey, did you hear him?
And I'm in contract on my own home in a little part of Marin County called Woodacre. So I'm just like on pins and needles about that. So that's keeping me occupied as well as all these other things. So wish me luck there, actually.
Great. Thank you so much for contributing to the magazine, the AOA magazine for the Northern California area. You author a column that's monthly. You do a legal Q&A, and we really appreciate that. You always are a resource
My pleasure.
When people have questions. They call us, and then we ask you, and you help us out so much. So really appreciate that.
One thing I really like is being able to give a good answer, a clear answer. There's so many times when I can't, though. It's, I'm sorry that, you need to, but when I can provide somebody with clear, information, I'm very happy about it. So thanks for the opportunity.
Right. And so just to remind you, thank you for joining. And we would like to invite you to join AOA if you haven't. And also, we would like to just remind you the AOAUSA.com website will have those forms for you, even if you're not a member. But we do ask you to go ahead and join AOA. And then also on that AOAUSA.com website, if you scroll down all the way to the bottom, you'll see a place where you can subscribe to a newsletter. And great. It's another live stream about ADUs and getting signaled here, not sure what. So anyway, it's about ADUs, and there's going to be like $1,000 opportunity there for you as well. So go ahead, hit the subscribe button. If this content was helpful for you, hit subscribe, and we'll deliver this type of content. And hit the like button if you liked it. I know that we can't please everybody, but we did want to please the Northern California members and everybody there that has questions. And so thank you for joining, and we'll see you next week.